Welcome tonight, guys. Advocates for Justice Paralegal School. We provide the tools, you do the work. I'm Coach Neighbors, and welcome to the show tonight. Still kind of getting things lined up here. So tonight I'm going to take you guys inside the 42 USC 1983 foreclosure offensive lawsuit package. The same lawsuit is in the traffic ticket package. The only difference is we changed the fact page, and that's all you have to do. So you can actually change that fact page to fit any situation. So this is going to be a very, very handy tool. I think it's going to revolutionize the situation, because now you're going to be going after them for the court processes and procedures and local rules that violate your right to due process. Until you can get those rules straightened out, you got crapola for the program. Okay, I'm just saying. You're not going to have a chance in hell if they're able to do what they do with their rules and stuff. I need to, anybody coming from Facebook, please go to this link and give StreamYard permission to use your Facebook name. Otherwise, you show up as a Facebook user, and I don't know who we're talking to. So it's nice to know who I'm talking to when we're talking, and other people can see who you are too, in case you say something smart or not. Okay, sorry. I'm just saying. Hey, Jim. Well, we about to get started, and we got a few things that we're going to be talking about tonight. So I'm just going to let that roll across the screen for a minute, and we're going to get started. So I don't know if you guys noticed, I said inside the 42 USC 1983 foreclosure offensive lawsuit package, I did not say defense. Okay, we about to throw that word out, because who the hell wants to be on defense? Okay, you can't get nothing done on defense. Well, you can get a little bit done, but you can't get done what we do. So in my program, you're not going to be on defense. And one of the things that you need to remember, if you invest in my program, you don't have to worry about answering to them, okay? Because anytime you answer to them, they're going to take those answers and stick them, well, back in your face in court. So we respond. If you read the federal rules of civil procedure, these rules are the rules that everybody's supposed to be following. If you read the rules, the federal rules of civil procedure, you will find that when it's time to respond, to answer, whatever, if you have defenses, you can throw them on the table. Yep. So if you sue them in federal court, not only do you have defenses, but you trump what they're doing, and then your stuff stomps their stuff out. And now they got to come answer to you. And if you get this package, you will be using the court docket sheet to prove that they violated your rights with the court processes that are illegal. So that's what we're going to be talking about tonight. And a couple other things. We have a new customer that's using the lawsuit package in a different manner than the two that I structured it for. Apparently, she's in the middle of a lawsuit against the city, and her attorney is stalling her out of statute of limitation time, and she's taking matters into her own hand. That's what she said. Yeah, and so we're going to be following her along the way, I hope, and we're going to see. Actually, I have a playlist that I put together, and that playlist is going to have other people like this lady. Her name's Dee. Going to have other people like Dee in it who come forward that are being violated by the attorneys by stalling you out of time and just sitting around not doing anything. So now people will be able to use this lawsuit package like these using it and go against and go after the attorney, the judge, the state. You want to make sure you have the state on there because the state is the one running all of this stuff. The state licensed all of these people to kick your ass. I'm just saying. And plus, to make that stick easier with the constitutional rights violations and all of that, you make sure you want to have the state in there. At the end of the day, the state is the one that has your deed registered in one of their offices. Yeah, and that registration of their deed is what create illegal registration of the deeds what created all this stuff. Problem that you have. And there is no law that says that you must register your deed. So you should get, and most people don't realize that registration of the deed allowed the first illegal lien to be put against your property. And I get a lot of pushback on this, and I just try to keep it clear, keep it simple. The first illegal lien that I put against your property, most people don't realize that the first illegal lien was the mortgage lien. And here's why. If there were several people that own property, all of the owners of that property would have to be present to sign a mortgage lien or any kind of lien against the property, right? Well, yes. So the fact that the lender accepted your signature on the mortgage lien proves that you own the property free and clear at that time, or they would not have been able to accept it. Thank you very much. Yep, Jim, the mortgage lien. That's absolutely right. That is absolutely right. It's the mortgage lien. So before we get started on all the juicy stuff, I want to remind you guys, please click on those ads so that I can get paid on YouTube for giving you guys all this free kick butt information. Make sure you click the like button if you respect what we're doing and find value here on my channel. Make sure you subscribe so that you can be in the know in the program, and ring that bell so that you get notification when it's time to rock and roll or when I upload new videos and things like that. So, and last but not least, make sure that you share my videos with people. Just post them. You never know who's in need of something, and or too embarrassed to actually say that they're in need of something. This whole mortgage thing is really embarrassing. I have people in the program that are not behind. I had a lady and her husband in Texas that were fighting to keep their property, and they actually have paid Sue and Jay Boyer. They actually paid they actually had all of the lien release documents, had everything to show the property paid off, but they're in foreclosure. Well, how could that be? Well, we've done some investigating and found out that they filed a fake assignment against their property. So where did they get the information from a fake assignment? From the county recorder's office. They got their property information for the fake assignment from the county recorder's office, where they have your stuff. So what I've been telling people to do is, if you invest in this program, in this package, you can use this to get whatever you want. So what the hell? So when I get on backed up against the wall, I tell them, hey, I go away as soon as you guys deliver my property deed to me as mandated in the state law. Get my freaking deed out of your office, deliver it to me, and erase all of the data and my information from your computer data or whatever, and then maybe we can sit down and talk about figuring out a way to make this go away. Because at the end of the day, that's what started it. And if you get your foot in the door, then you should be jamming them up for everything that you need. Welcome to the show tonight, Lauren. So before we get started then we got a couple before we get started today. I got a little session that I want to do. I'm going to add lesson learned, and that's going to also be a new playlist. And we're going to talk about things that people are going through. Like, for instance, what is a status conference? And I just made up a fake name here. So if your name is Tom and this happened to you, then I'm not talking. I'm not talking about you, Tom. If you're Tom, I just made a fake name, Tom, and that's what we're going to use to show this problem. So Tom went to a status conference, and at the end of the hearing, he complained because that he didn't get a fair trial. Well, actually, he complained that he did not get a trial. And he said the judge told him that his trial was over. Yeah, his trial was over. Tom went to a status conference without understanding what a status conference is. He went there without Googling without Google searching the word status conference to make sure he understood what status conference was for and what they might try to do or whatever. So what I did was, and this is how you learn. I know you guys think that we need to go to the law library and do all of that stuff and look up all of their fake statutes and stuff. No. And here's the link. I Googled status conference and pulled up this link. Now I'm going to do a screen share and show you. But you can click on the link, open it up yourself so that you can see it better. Okay, so here we are. So this is actually not the first page. This is what it looked like when I did the search. Status conference court. And so usually the first one is good if you're just looking for an explanation. So status conference. So a status conference, let me get my microphone a little closer. I don't know if you guys can hear me there. A status conference is a meeting that occurs before trial where attorneys and the opposing parties are sometimes the judge meet. The nature of the status conference will often depend on the type of case. The status conference is in a criminal case consists of the prosecution and the defense attorneys exchanging evidence. Okay, well, that's key. So remember that. But they sometimes may involve in discussing plea bargains. So let's get on to it. In a civil case, a status conference can involve exchanging evidence again, stipulating two terms, the parties' negotiation on a settlement agreement, and sometimes the judge will attend the status conference to give their opinion on plea matters offered and setting timelines for other pretrial matters. So basically, a status conference is an evidentiary hearing. And if you don't understand that and you don't object to anything and you go in, then you end up kind of in a jam. Because from reading this, what they do is if you don't object or say anything, then while the attorney's talking and putting it on, then they're just going to go with what they said because you have no idea what you're doing. And that's your trial. That's your trial. Your trial would be like that anyway in an eviction court. You have no chance. The goal is to move that stuff over to federal court after you sue the judge. That's how we do it. The trial is going to be the same way with the judge and so we learn here that had Tom pulled this up and understood this, then maybe he would be in a different position and not facing the judgment now and trying to overturn judgment. Now, that don't mean Tom's done and he needs to go back. I mean, Tom needs to object. Whenever the judge rules on anything, you're supposed to object, and you object for all of the reasons that you have in the documents that you've been filing in court. It's easy. But people don't read the shit. They don't read it. They don't take the time. They just act like it's the conventional program. I had a lady call me. She had the documents 2 months, and all she did was file the restraining order because she. So I asked her, so why are you asking to restrain them? If you haven't filed any other documents, then what are you restraining them? Well, I don't know. Well, to restrain them, you have to show that you're going to be injured and that somebody's messing up. And if you haven't filed any of the other documents, then you got nothing for the program. And it's sad, but I guess I don't know. I can't help everybody. You got to be on the program, be watching the instructional video, and people let too much time pass. They think that, oh, I have time, or I have 15 days. No, you don't. They already stole your money. They already pocketed the electronic credits for the deal, and now the foreclosure part and all of this dog and pony show is just wrapping up paperwork. That's my opinion. It's just wrapping up paperwork. And that's why, boy, it's like pulling tooth to get to kick their butt and make them go sit down. Let me turn off this screen share. Now, you guys can see how easy it was for them to take advantage of Tom. And they're not going to happen, and I lost my stuff there. Okay, we're back on track now. So, like I said, the first thing you guys have to do is you have to object to their nonsense. If you don't object and you agree, so I'm pretty sure Tom left out of the court, trying to argue the title dispute, which is that he owned the property or whatever. But see, here's the thing: an eviction court doesn't have jurisdiction to hear the title dispute, and if you don't know that and you argue the title, they're going to ignore you. And if you don't know what you're doing in there, they're also going to ignore you too, just like they did. Thanks, coaches, Bridges. I figured it out there. The wrong thing got closed up when I was trying to close up the screen share. So we're back. Maybe. Okay. Now let's just finish this puppy up. Now, you guys, you take a closer look at what the hearing was. you'll see that it was pretty much a controlled situation for them to go through the process and continue with what they wanted to do, even though they didn't talk about it specifically what they're going to do. They already, yeah, it's real slick how they do that. So if you don't say the right thing in court, and they'll just let you flop around and then grant the eviction process, and now you're looking at 10 days. They will not help you. And some people go into court thinking they have rights and they're going to help them. And no, those people find out when they get slapped in the face that they're not going to help you because they don't care. They want to take your property. So you should never go into court without doing your homework and understanding what it is they're trying to do. You should never go into court. Thank you. You should never go into court without doing your homework. I'm just saying. Now, if you do get yourself caught in a jam, you always want to object, demand reconsideration, and then sue the judge. It's a 1, 2, 3. I'm serious, because they're going to continue stomping on your rights with their processes until you sue somebody. They're a corporation. They don't have anything to do with the Constitution, and that's why they don't care about your rights. They're a corporation. They operate from statutes, revised codes, and statutes. And we already know that revised codes and statutes do not have the necessary elements to be considered a real law. They're public policy. You always have to Google the words that you don't understand. And, I think from most people's perspective, it's easy to see the problem is the unfair court process. At the end of the day, at the beginning of the day, oh, you need to file this, you need to do that, you got to do this, and they have you running all around. All of that stuff is BS. So you have to attack that. Well, that's the first problem that you have to attack. Now, let's get back on track. 42 U.S.C. 1983 Civil Rights Foreclosure Offensive lawsuit package. What makes it special? I know that's what you're thinking. So that's where we're going to go now. What makes it special? And I keep it simple and short, okay? Because we don't need to have a whole bunch of stuff. What makes it special? What makes it special is that you're going to be suing the state and the players for the unfair court process. Until you address the court process, violating your right to due process and other stuff, you're not going to have a chance in hell to get anything accomplished. And when the attorneys say in court, people go to these hearings, when the attorneys stand up and start their little BS in court, the first thing they start, Mr. So-and-so signed the mortgage, took out a mortgage against the property and blah, blah, blah. And once he said that you took out a mortgage against the property, I would object. And I would reply, the fact that the lender accepted my signature on the mortgage lien proves that I own the property already. The fact that they accepted your signature on the lien proves that you own the property, or some other owners would have to be there to sign. I'm just saying. I mean, I'm keeping it simple. Somebody help me here if I'm on base on that, but that's the way, So I would not stop there. I would follow it up. And the things that I'm going to teach you now are the things that I use in online course. The online course stuff is different, is hyped up, and the people in the online course will tell you right now that they don't play the online course. I don't hardly hear anybody from the online course. But here's the thing. The next thing that you want to do is you want to tell them that the court needs to have a copy of the original contract on file, because the contract that they have on file is missing the 6 missing things. I talk about that in in the online course. Now, I'm not going to tell you what all 6 of those missing things are. You wouldn't need to take the course, but they're pretty powerful. And one of the things is that you and the lender agreed that the lender was going to do the deal according to the GAAP accounting laws, the GAAP accounting principles. Those are the banking laws that they were supposed to follow, and they didn't follow them. So these 6 things that you throwing on the table are the way that whole deal was supposed to went down, but it didn't. So they can't say, well, we didn't follow the GAAP. They can't say they did either because they didn't. So these 6 things, either way they go, they're screwed. So and this is a different strategy to force doubt and to make the court need the original contract. Okay. We used to say, whatever it was, but they don't care about none of that. You have to increase the liability and allow all of them to visualize it in a shared capacity. That's what you have to do. So we use those 6 missing things in our online course, legal documents, and they are the bomb. Now, that's not taking anything away from the documents that we got already going, and we're going to talk. I'm going to open up the screen share again, and I'm going to show you guys the lawsuit package. We're going to go inside the lawsuit package and take a tour. But I'm not going to show you everything. I'm just going to give you a little peek. And actually, what I'm going to do is I'm going to spend a little time going over the title of it so that people understand the words that I got in the title, because a lot of people don't understand and they don't realize how powerful the stuff is that I have in there. So we're going to do that. Now, when you invest in my program, you will get zip files like this. Anytime you need to open a zip file to review what's inside of it, you will need to watch the instructional video for using the documents in that zip file on my YouTube channel. So you would go to my YouTube channel and then you would search for the instructional video playlist. And then on that playlist, you would search for the title of the words here and watch the video. So there are some zip files inside of other zip files so my goal here is to provide you guys with all of the stuff that you need to address all of the fraud that I'm trying to do. So it's gotten a little thick, but with the group, the Facebook page, the people in the group are helping me figure out what we need to have in it. So we've added things or whatever, so you don't have to keep coming back or whatever, and it's a whole lot smoother process. Now, when you open it up and you see there's 26 or 27 documents in there, and then you open on this one, that might have 15 or 5 more or something, and people start freaking out. But what you need to remember when you get done breathing in the paper bag is that you can only do one thing at a time. The steps are laid out. All of those documents is not what you have to worry about filing. All of those documents are for a bunch of different things. Some of you are already halfway in the process. Some of you are already at the end of the process, about to get pushed off the cliff, so so you don't need to worry about all of them, but keep in mind, if you're at the beginning, you would have everything you need. So then either one of the packages. Now, this package is really special because it allows you to go after the parties for violating your rights with the illegal court processes. Thank you, Carrie Jackson. She sent a super sticker. She finds value in what we're talking about tonight. I think just taking the time to send it is really cool. It don't matter if it's 50 stinking cents. I think it's cool as hell. So thank you, Carrie Jackson. So let's just get this open up. So when you open up one of my zip files, you can't do it on your phone. I'm just going to tell you now. Spend 2 hours a day yesterday with, you cannot open a zip file on your phone. So I'm telling you right now. And the other thing that you people need to know, especially the older people, and I know this from because it happened to me. I'm all right. I'm just going to say it. Okay. So when you open up a zip file and you need to you open a zip file and then you open up the document that you're going to work on, you need to copy and paste it in another Word and then close that back up and make your changes over here on the new one. If you don't, when you get done and you close that document back up, it's going to go back into the zip file and it's not going to save any of the changes. So that's very important to remember for you old people. And maybe some of you young people, I don't know. But when you open up the zip file, this is what it looks like. Well, this is what it looks like when you first open it up. And then this is what, so you'll click on it once, then you have to click on it again a second time to open everything up. And here we go. This is the new fire. So we got a notice of default. This is the actual lawsuit document. We're going to open it up first. We'll start with that first. And then we'll do the restraining order. Those will probably be the order that most people would be filing this. There we go. Open up here. So we're going to move it down. Okay, so this is the bomb. Now, I made this for myself. So I'm just going to tell you, this is some of my best work. I made this for myself because I got a government agency messing with me and I'm about to take care of this problem. So, and I'll have a playlist for that too, keep you guys up to date on the process of that. So you guys can see here, $20 million claim under 42 USC Code Section 1983, action for deprivation of rights of civil rights, violation of the Tucker's Act. Now, I don't think you guys know what the Tucker's Act is, so I'm going to tell you what the Tucker's Act is. The Tucker's Act is a federal law that was enacted in 1938. I think it was 1938, that forces the state to adhere to the civil rights. So what this did was it removed the state's qualified immunity for violating civil rights. So they can't use this. Well, they can say they have immunity if you don't use this or you don't know about this. But when you know about this, it's a little problem for them. So we come in right with that because that's the first thing they try to throw on the table is, oh, I have immunity and I can take your shit and do whatever the hell I want to you and you can't do nothing about it. So, hey, Ralph, welcome to the show tonight, buddy. So that shuts the door on that real quick. And you can look this. So that's the other thing too. I want to tell you guys, how people giving me a hard time. I'm not telling you guys to believe me. Okay, I'm giving you a point to start your research on. Do your own research, and let me know what you find. Because I got a lot of research here, and I already. But you have to do your own research. I'm not telling anybody to believe me. Do your own research. There you go. Google Tucker's Act codified at 28 USC. There you go. Yep. Also in violation of the Administrative Procedures Act of 1946. Now, this is huge. This is the hugest. This is huger. Most people don't realize it. The Administrative Procedures Act of 1946 is a federal law that was enacted in 1946. And if you want to research this, you're going to have to you're going to have to make sure you add 1946 on the end of your search, or you will get Cornell Law Library watered down BS, BS, BS. So that's what I got to say about that. Now, the Administrative Procedures Act of 1946 is a federal law that was enacted in 1946. And this law forces these corporations to have their policies and procedures in line with the Constitution. And they are not. Now, this is administrative in nature, so you can't get money for it, but you can sue them and force the court to make them change their policies, or you can sue them for their corporate charter, which case would give you a seat on the board of directors, and you could have some say in their policy making procedures. Yeah, you can do whatever you want. Okay, my program is only limited by your imagination or your fear. And if you got fear, don't bring that shit in. Okay, sorry. So a lot of people, I had a lady I talked to, she passed out my work because she saw the title, and it wasn't about, oh, wait, also for a violation of due process. There you go. That's all. That right there, the end part right there addresses your stuff. Okay. But let me tell you, all of this is way more detrimental to them than this. And when you put all of this with this, so now they're violating federal laws and your right to due process. And you can add a whole bunch of more stuff in there, but I like to keep it simple. And when you come in with the Administrative Procedures Act of 1946, that's a problem that these corporations do not want to deal with. Okay. That's way more important than what happened to you. Because the goal here is use your leverage to make them give you back your deed. Remember, we talked about let them deliver your deed as mandated by, okay, yeah, you know what I'm saying. There's the Tucker's Act. So you guys can see that this is not something that they're going to take lightly. So now we're going to take a look at the next document. And the next document that most people would be now have the USA affidavit of state citizenship and all that stuff. That's a whole different program. That's something that you want to get on the record to help you down the road, especially if you're about to be pushed off the cliff. You need to focus on the fire right now that we just got done talking about. And I put this restraining order together specifically for this situation. Well, the 42 USC Civil Lawsuit Restraining Order. And it's pretty powerful. So it says right here that, you can change this non-judicial, just take it off the picture. That should be colored in red. But you change the red font, but keep in mind that I did this stuff myself, so you may need to change some other stuff, but don't take stuff out, because there's stupid stuff in here like deliver difference that you have to have in there, and there's some other stuff that you have to have, and if you don't have those things, then they're going to throw your stuff out. Lori, we're not going to talk about your stuff right now because I'm doing education. So at the end of our show, I'll take questions if they're pertaining to using my stuff. But we're not going to review your case or talk about all of that stuff because I'm not an attorney and that's not what I do anyway. Tonight, Saturday night is education. So I'm teaching some things here. And at the end of the show, I will take a few questions if they're related to what we're talking about. And that's how we're going to do this. So thank you. And we're going to move forward. So this restraining order here, you can see we're demanding a hearing pending the $20 million claim. and under the USC 4119, Declaration of Rights. So you will file this in your case also, and then use this to control the state court if they're still squirming over there. So, but the way this should work is if you're like tight about to get thrown over the cliff, I would file this lawsuit that I just showed you in state court first to stop everything and jam that up. And then I would go and file in federal court and just pay and file and then move all of that stuff over there. Is how I did it with my sister's case. And that's working out really well for me. Once we moved the attorneys for state foreclosure over to federal court in interest of justice, because we sued the state court judge, there was nothing that they could do. They were they were really freaking mad. I'll tell you that much. They were really, really mad. And they actually called the police on my sister because they didn't like the emails that my sister sent them, letting them know what we were going to do. And the police didn't think there was a problem with the emails. And so that's the first time I ever had the attorneys call the police on somebody because they were scared. Oh, wait, they also wanted the police to make us stop delivering stuff to the house. Well, my sister sued the attorney for his property, and his wife's name is on the property too. So they both had to be served. So I think I think the attorney was really mad that his spouse was involved in a situation. Yeah, so you guys should always do that. If you include their property in your claim, then you need to make sure that you serve both parties, because both parties' names are on the property. That you got to serve both properties. So let's just move on here. The restraining order is pretty plain and clear. This package, you see, it's only 1, 2, 3, 4, 5, 6 documents in it, and you really don't. I don't think you need any more than this, because this is pretty powerful. So the next one we're going to look at is the notice of default. Well, no, we're going to look at this one. Demand and strike the attorney's notice. I use this a lot, and this is a very powerful document. We demand to strike the attorney's notice of appearance. So attorneys have to file a notice of appearance because they are a foreign agent. And here's the problem, and you can like make another document to address this. The problem is that a foreign agent cannot file a case in state court. A foreign agent would have to file in federal court. You can't sue someone in another state from state court. Excuse me. You have to sue them in federal court. So that's the problem. So what we've done is we're attacking them to strike the attorney's notice of appearance, because corporations can't represent themselves in court. Number one, they can't represent the law firm that they work for. They can't litigate a case they're a party to. They can't do none of that stuff. And the attorney is not registered as a foreign agent, which under the Foreign Agent Registration Act of 1938, they're supposed to be registered, and all this paperwork is supposed to be available for people to see. None of that stuff takes place. And that's a federal law also. So yeah, this turns up the heat on them just a little bit. The goal that we do is attack the court. We're attacking the court, we're controlling the court process by holding these people accountable. It's like they're trying to do you. Except they're holding you to a bunch of rules that they're not following. Now, this also has a notice of default, because they're not going to be able to respond to any of this by counter affidavit. You're responding by affidavit, they have to respond by counter affidavit, and they can't because they're lying. So this is your demand demand for default. And I didn't use this in my sister's case because we didn't have to. We didn't want to. We just moved it. And then once we moved their state foreclosure case over to federal court, once we moved it over to federal court, we moved her lawsuit, her second lawsuit that she filed for $20 million. The first one was only for $5 million. And then when they terminated her case, she dropped it against my better judgment. And then so when they started acting stupid again, she filed her second lawsuit, and and they never responded. And they didn't respond because they had their little game plan about what they're going to do to us and all that, until we jacked that all up. So we moved her second lawsuit over to federal court, did the removal process. And then once we got it in the court and it had the case number on it, we filed for summary judgment. And we filed for summary judgment. We included a copy of the docket sheet to show that 75 days had passed and the attorney did not respond to the lawsuit for $20 million. So that's the problem for them right now. And you know what they're going to do. Oh, wait. We also filed the sanction motion. I need to put that in here. Let me make a note. And I used the sanction motion as a mini lawsuit inside of the other lawsuit. It's not a counterclaim, so they don't get they can't respond to it anyway, because you're moving for sanctions under Rule 11, which states that they have to do a reasonable pre-filing investigation, and they never do. So they never do a reasonable pre-filing investigation. And in this case, you can also move for sanctions if they're litigating a baseless case. And in the case with my sister, it was terminated. And termination is a final judgment, is a final order. In order to get your foot back in the door, you have to come in or move a court, and you have to have some new evidence that you did not have access to. It's pretty complicated. Well, when you're following the court rules, but not for them, because they don't have to follow those stinking rules until we move their ass over to federal court. And the federal court judge ordered them to respond to our motion for summary judgment. We're like, what? So I think moving the case over to federal court, it needs to be in your program. And it's easier to do after you file your lawsuit against the judge. Because think about it. Now, no other judges all the other judges would have conflict of interest. So, that's going to be a problem. So, and that's what we got going on now. Of course, the federal judge was like, well, I think I'm not sure if federal court has jurisdiction or not. The attorneys brought up a good point, and he asked us to stop filing stuff in the case until he figured it out. And then we moved to appeal him telling us to stop filing stuff and not granting our motion for our restraining order. And I know that we couldn't, they were going to send it back, but actually they sent me the thing. I could have filed it if we wanted to and paid $400, but that's not what the goal was. The goal was to let those buttheads know that we're going to be whining to the appeals court the whole time. But what we didn't tell them was we're going to be suing them too. Because here's the thing. It don't matter if you're the plaintiff or if you're a defendant in a case. Well, just work with me here for this point. It don't matter if you're the plaintiff or defendant in the case. The judge is supposed to owe you the same courtesy to do the right thing and support your rights and all that shit, but they don't do none of that stuff. So that's what I mean when I say that. At the end of the day, it does matter. You never want to be the defendant, because if you're the defendant, you're in their program, and you're going to be getting punched in the face a whole bunch of times. So. The affidavit of state citizenship, we're going to open it up. Now, there's also a PDF that goes with this that I need to put in this package. Excuse me. And I don't have it in here yet. So the PDF explains everything that you need to know to reclaim your state citizenship by applying with the state and getting your card showing that you're a state citizen of the Republic state you're born in. So, but this you can use to to jam the court up and let them know that you are a state citizen and you're doing it by affidavit, so they can't deny it because they can't sign the counter affidavit denying it. And I pretty much include this in all of my stuff. So, and a lot of people, if it's not in there, I send it out. So if you bought something and you didn't get it, tough. Okay, never mind. Most people got it because I try to make sure that this is real important. By completing the process on the PDF, you can get yourself on the do not detain list. So the po won't be messing with you when they pull you over. And the last thing that I put in here is this. And this is like really badass. And I put this in all of my packages. The Banker's Secret Manual. This, now keep in mind when you read this guy really hates the banking system and all that, but we ain't messing with the bank, okay? Because people mess with the bank, have flowers growing on top of them. But we just messing with the attorneys, okay? We're not messing with the bank. But this has a page in here where it talks about the banker's biggest fears. And from that page, I got, from that chapter, I got the tips and the points that I needed to help me structure the things that we talk about, the 6 missing things, and how to incorporate those into your program. Yeah. So this is a great reference to learn from. So that's pretty much it on the package. I tried to keep it simple. I don't see how anybody's going to be able to argue any of the stuff that we have in there. So um, I can't wait to get feedback from people that are using it. And I have a few people that are using it, but you know how it goes when you back the attorneys up against the wall. And when you back the attorneys up against the wall, they make you sign a non-disclosure statement before they do whatever it is that you need to have done. So you can't be telling everybody that you kicked their butt. Yep. Thanks, William. So that's all the value that I'm bringing to the table today. I want to thank you guys for the privilege of your time. Does anybody have any questions that they want to ask? You can throw them on the table now, and then I'll talk about them if I think they have value. Now I put a link in the deal here to the package. Oops, no, that's not the right link. So you guys can go to it if you're interested in it. You know, you should be able to, if you're struggling, get someone to go in with you, and you guys work together. That'd be the best thing. Everybody wins on that program. Here you go. There you go, William. You can go check it out. If you're not looking at the value that you're going to get, then you're not going to be sure if it's worth where we're asking. There you go. Okay, I'll go ahead and hook you up. We have that package on sale for $600. The lawsuit package that you need for foreclosure defense is on sale for $400. $400. Okay, where you're going to go and get something $400 going to help you save your house. So Evan says he got his package and thanks. If you're already in federal court and suing a judge there, isn't that a little dicey? I don't know what you mean by is that dicey. I mean, you got to do what you got to do. It's not dicey as packing up your stuff and moving or having your shit thrown out in the front yard. So that's what I got to say about that. I don't do well with people's fears, so you can keep those to yourself. Because I asked a lady one day, was more fighting in court or packing up, getting her stuff, having her stuff thrown out in the yard. She told me it was 50-50, so I hung up on her. Yeah, then I called her back and she said she got the point. She got my point. If you're not willing to do whatever it takes, you should not be using my stuff. I'm just saying. If you're not willing to do whatever it takes, don't use my stuff. And my stuff's not for everybody. And I'm just going to say that now. And when people call me that aren't sure, they find out real quick that I don't spend time trying to close them or convince them or any of that. Because if you don't see the value, you haven't done your homework and it's not going to work for you. And I don't want your money if you don't see the value. So that's kind of how I roll. So I appreciate you guys' time tonight. I'll see you in the next video.